Welcome back to Organized, the business law breakdown, where corporate law meets high-stakes drama and questionable decision-making. I'm Professor Seth C. Oranburg, and today we're getting into what happens when directors violate their fiduciary duties. In the last episode, we laid out what those duties are: care and loyalty, and maybe oversight. Today we'll talk about how they go horribly, horribly wrong. Because when directors drop the ball, they don't just lose their jobs, they can also get sued. Or more accurately, the company gets sued, stockholders lose money, and lawyers have a field day. You know, there's that joke that no one wins litigation except the lawyers. That could be you one day. So let's talk about the most common ways boards screw up, and how Delaware courts decide who's at fault when lawsuits start flying. When boards fail, it usually falls into one of two categories. They were careless or they were corrupt. Sometimes they're both. Careless means there's a duty of care violation, and corrupt means a duty of loyalty violation. Let's start with the duty of care. This is where things can get messy fast. A shorthand for the duty of care is, we didn't know, we weren't paying attention. That's why some people call this the duty of oversight, the obligation to pay attention, but as I mentioned, I roll the duty of oversight into the duty of care. In any event, the duty of care means directors must be informed and act with reasonable diligence. So what happens if they don't? Meet Smith v. Van Gorkum, the 1985 case known as the $700 million disaster. The Board of TransUnion, a financial services company, approved a massive merger in about 2 hours. They didn't read the financial reports. They didn't ask for a fairness opinion. They just nodded along and voted yes. And given it was 1985, maybe they had a few martinis along the way. Fast forward, the shareholders sued and argued the board was grossly negligent, and the Delaware Supreme Court agreed. The directors were found personally liable for failing to exercise due care. But here's what's interesting. Delaware law actually changed after this case. After Smith v. Van Gorkum, the Delaware legislature realized that this situation made directors nervous. And nervous directors means Dexit, exit from Delaware. And that's a big loss for a state which gets revenue from two sources: corporate taxes and that damn bridge. So after Smith v. Van Gorkum, the Delaware General Corporate Law was amended by the legislature with Section 102B7, which actually says, basically, you can waive the duty of care violations unless there's fraud or bad faith. Fraud is obviously quite serious, but it's certainly more than recklessness or gross negligence. And it turns out that many public corporations elect to put this in their charter. So today, if a board is careless, they're off the hook as if Smith v. Van Gorkum never happened. But at least it's an interesting story in how the Delaware legislature changes to try to entice management to stay in the state. What if a board knew something was wrong and ignored it? That's when people start to talk about the duty of oversight, which can be shorthanded as, we didn't see any red flags. So sometimes boards make actively bad decisions. We talked about that with regard to Smith v. Van Gorkum and 102B7. Sometimes they let bad things happen on their watch. And that's where the duty of oversight comes in, which, as I mentioned last episode, is either a portion of the duty of care, as I see it, or a separate violation, depending on who you ask. The classic case is In re Caremark. It's a 1996 case. Caremark's board failed to notice their company was illegally paying doctors to refer patients to them. These are called kickbacks, by the way. Not supposed to do that. The result is shareholders sued, arguing the board should have known. The court ruled that directors are not liable just because something bad happens. But if there's a pattern of misconduct and the board ignores it, they can be on the hook. So let's fast forward to 2019. Marchand v. Barnhill involved Bluebell's board ignoring food safety warnings for years, although there were known warnings that these factories were potentially producing dangerous ice cream. There was a dangerous, deadly listeria outbreak, a massive recall, millions in losses, a couple people died, and the Delaware Supreme Court held the board accountable. The brief lesson: if you're on a board and there are red flags, you better start asking questions. Let's turn to the duty of loyalty, where directors are self-dealing. The duty of loyalty means that you can't have a conflict of interest with the company that you serve, or at least you can't act on that conflict of interests. Instead of talking about all the details, let's talk about where it's really complicated. What happens when the CEO is also the largest shareholder and uses that power to get a really big CEO pay package? Enter Tesla and Elon Musk's $50 billion salary. Well, it wasn't a salary per se, it was based on performance, but Musk stood to earn $56 billion. In the case of Tornetta v. Musk, shareholders sued. They argued that Musk negotiated his own record-breaking compensation deal. He had a board filled with his friends and loyalists and didn't provide full transparency to shareholders. Interestingly, the judge ruled that Musk loses, but it did it for a really odd reason. It said that Musk was a superstar CEO who basically had everyone under his sway. A really weird part of this case is that the shareholders approved the transaction, but I guess Musk did some kind of hypnosis on them and tricked them all into thinking that he was magic. In any case, after the case was decided, once again, kind of like Section 102B7, the Delaware Supreme Court issued SB 21. SB 21 created much clearer standards for when a director has enough control, and Musk wouldn't have made this qualification. The idea, though, is that if the CEO controls or dominates the board, we have a different standard that applies called the entire fairness standard. Under the entire fairness standard, we don't apply the business judgment rule. If there's a conflict of interest or if the board is dominated, we actually have to prove that the deal was 100% fair. Remember that otherwise we have to just prove it wasn't terrible or you weren't a total numbskull when you agreed to it. This also ties back to Weinberger versus UOP, which is a 1983 case. Directors on both sides of a merger had insider information and used it to benefit one side or the other. The Delaware Supreme Court ruled that's exactly what a breach of loyalty is. And when there's a breach of loyalty, the standard is entire fairness. Again, entire fairness means you have to prove the deal was 100% fair, not just that it wasn't the stupidest thing that happened this week. So, in sum, if directors are careless, they're protected. If they're reckless, they may even be protected if the company elected a 102B7 exculpation provision. If they ignore obvious problems, they're probably in trouble under the Caremark standard, which some see as a duty of oversight. And if they enrich themselves, well, then they better lawyer up, because one of the few things you can't insulate yourself from as a director is self-dealing. So let's talk about those shareholder lawsuits when you have to lawyer up. There's actually two different ways that they can be formed: direct and derivative lawsuits. It's interesting because, as I mentioned, the directors typically owe their duties to the corporation, but they control the corporation. So if you controlled a corporation, would you decide to sue yourself? Don't answer that, because most people would probably say no. Look, there are two types of shareholder lawsuits. Direct lawsuits where the shareholders say, I, as a shareholder qua shareholder, was personally harmed. And derivative lawsuits where shareholders say the company was harmed and I'm suing on its behalf. And that's interesting because shareholders, as we talked about, don't control the company. They don't control who it sues and when. We'll cover derivative lawsuits in more depth later this season. But I want you to just pause and recognize that the directors control the company, including when it decides to sue and when they decide to sue themselves. But first, let's just reflect on understanding fiduciary duties. Directors have the duty of care and duty of loyalty, and some people will also put the duty of oversight in one or either category or call it something else. If directors violate these duties, who holds them accountable? Sometimes it's the courts, because the shareholders will sue derivatively or directly. The SEC, the Securities and Exchange Commission, can also sue the directors of a corporation in some cases. In the next episode, we'll dive into how shareholder activism is reshaping corporate governance, and why activist investors can either save a company or burn it down for their own personal interests. But until then, I'm Professor Seth C. Oranburg, and this is Organized, the Business Law Breakdown. I'll see you next time.